Parviz Jarabi, attorney at law, have been practicing for over 20 years. Our office located by San Francisco Airport, specializing in employment law. Today's topic, tips law in California. A tip is the money a customer leaves for an employee over the amount due for the goods that are sold or services provided. Tips belong to the employee, not to the employer. In California, your employer cannot take your tips or any part of them from you. Your employer cannot deduct money from your wages because of the tips you earned. More importantly, your employer cannot use your tips as a credit towards his or her obligation to pay the minimum wage. California law requires that employees receive the minimum wage plus any tips left for them by customers of the employer's business. When a customer pays their bill with a credit card and the payments includes a tip, the tip portion must be paid to the employee soon after, but not later than the next regular payday following the date the customers authorize the credit card payment. So, if the employee gets paid on the 2nd and 17th of each month, and the customer paid his or her bill, which included the employee's tips on the 5th of a month, the employee must then be paid the tips no later than the 17th, which would be the regular payday following the customer's credit card's payments on the 5th. Also, keep in mind that your employer must pay you the full amount of tip that is indicated on the credit cards, the full amount the customer has left for you, nothing less. Your employer may not make any deductions for credit cards processing fees or costs that are charged to your employer by the credit card company from the tip that the customers have left for you. Employers are responsible for paying the entirety of the credit card processing fees and any costs associated with using the credit card system. Although the entire amount of tips left by customers is yours to keep, but when working in a restaurant, for example, your employer can require you to share your tips with certain other employee only, such as a busboy or bartender who either provided direct table service to the customers or were in the chain of service provided to the customer's overall experience. This type of a tip sharing arrangement is called tip pooling. Now, while this tip pooling policy is allowed to share tips, but such tip pooling policy cannot be used to compensate the owners, managers, or supervisors of the business, even if these individuals should have direct table service to a customer or are in the chain of service to a customer. Sometimes your employer adds additional charges called service charge to the customer's bill, such as for large parties. Service charges may or may not be considered a tip. This depends upon several specific facts as to what customers thought the service charge was meant for, whether customers had unrestricted right to determine the amount, if the amount of service charge was paid free from pressure, or how the service charge was described, and also the custom and practice of the industry. Therefore, determination as to whether the service charge is considered tip and would belong to the employee may be assessed through examination of several specific facts I just mentioned. Please contact my office with any employment law questions for free consultation. Please be sure to like and subscribe and turn on your notification.